want to start by saying hello and welcome, and thank you for joining our presentation today. Our Business Builder Speaker Series was an idea out of 2020 in the COVID days when we couldn't get together in person. We said, let's get together on Zoom once a month and we'll bring on a speaker on a topic that we think is important and valuable to real estate agents. And that's where our Business Builder Speaker Series was born. It's the third Wednesday every month at 10 a.m. with great tips and tricks from industry experts to help you grow your real estate business. We know you're busy and we appreciate you taking the time and joining us today. To make the most of your time, we encourage you to ask questions. It's a small group. You can unmute yourself and ask them out loud, or you can go ahead and use the chat box. We encourage you to stay connected with us. You'll find links to all of the different socials, and you'll find us there. Additionally, on our website, schaeferitz-dean.com, under the Resources tab, you will find all of our prior episodes of our Business Builder Speaker Series. You're welcome to go back and review any of those topics that are of interest to you, or to share them with others who might benefit from that information. We will ultimately add this one to the library on the website as well. In case you missed it, here are our year-to-date speakers, and you'll find each of their presentations in the Resources tab on our website. Mark your calendar. The Business Builder is the third Wednesday every month, which means next month it'll be Wednesday, August 11th at 10 a.m. Next month, we're going to have Skip Wilcox from Kairos Sales Group, winning more listings in any market. Skip's a dynamic speaker and a trained sales trainer, so I know that you'll get a lot of value out of his presentation next month, and we encourage you to join us next month. This morning, I'll be presenting on Deeds Done Right, what every realtor needs to know about the Todd transfer on death deed and other essential deeds. My name is Doug Dean, and I'm the owner and managing partner at Schaeferitz and Dean. We formed January 1st, 2008, so we've been around over 18 years, over 32,000 transactions, over $6.2 billion with a B in transactional volume. We've been around and have a good history and track record, and we appreciate you joining us today. I'm going to change my screen sharing to the presentation. Our topic today was about deeds done right, what every agent needs to know about the transfer on death deed and other essential deeds. Our objectives when we're done with our session today at the end of the presentation, I hope you'll be able to understand the purpose of various types of deeds, identify situations where specific deeds might be appropriate, recognize title concerns related to deeds, understand limitations of agents' involvement, know when to refer clients to an attorney, and be able to better prepare clients for a smoother closing process. Why agents should care. Deeds are critically important to both of our businesses. They impact who legally owns the property, whether title can be conveyed, probate considerations, estate planning rules, financing eligibility, the future saleability of the property, and potential title defects. One incorrect deed can delay or derail a transaction. What is a deed? When we talk about a deed, what makes a deed a deed? A deed is a legal instrument that transfers an interest in real property from one party to another. And Common characteristics of a deed. A deed generally requires a grantor, a grantee, a legal description of the property, a present intent to convey the property, proper execution of the deed, and delivery and acceptance of the deed by the grantee. The first one I wanted to mention because it's the newest. It was formed by the Georgia legislature in July, I believe 3 years ago, called the TOD or Transfer on Death Deed. Other states have had this concept much longer than Georgia, but it's new in Georgia. The idea with a transfer on death deed is it allows the property owner to designate the beneficiaries who will automatically receive the property upon the owner's death. If you've ever had a checking account and you designated the checking account payable on death to someone, that means that it is your checking account. No one else has access to it for as long as you live. But at your death, the bank will then make those funds payable on death to someone. And the transfer on death deed works in a similar manner. You designate the beneficiaries, and on your death, there are certain steps. They have to take the procedural step of recording in the deed records an affidavit that they accept the transfer, the gift. They recite that the grantor is now deceased, and by virtue of the transfer on death deed, they are now the new owner. Benefits to the transfer on death deed is it's a way to avoid probate. The other good advantages of the transfer on death deed is the owner retains full control of the property during their life. The owner has the right to revoke a transfer on death deed before they die. If something happens, they can change the beneficiary, and beneficiaries have no ownership rights in the property until the grantor dies. Before the transfer on death deed, what a lot of people did for estate planning purposes is they would just add someone as a joint tenants with right of survivorship so that when they die, their co-tenant automatically took the property. There are a lot of problems with that scenario. The first one is what if you later have a disagreement with that person and you don't want to leave the property to them? It's not easy to undo a deed. The other thing is they're already on title and an owner. So you lose the independent right to control the property. If you, for example, if you're a grown parent and you add your grown children with the well-meaning intent that they'll take it through the joint tenancy when you die, and later you want to refinance the property, they can block it. They're a co-owner. They have to consent to you taking a loan against the property. So there are a lot of drawbacks to doing it that way, and a lot of those drawbacks are avoided through using the transfer on death deed. So now I've told you all the benefits to the transfer on death deed. What are some of the drawbacks or risks? First, it may not be appropriate for every estate plan. If you're working with an estate planning attorney, they may have other ways that they want to transfer the property. It also might, your transfer on death deed might potentially conflict with other estate planning documents and arrangements that you've made. And also, it shouldn't, but in the future, it could affect title underwriting requirements. The grantor of the deed remains the owner of the property for their lifetime, but it is something to consider. The different types of deed, other than a transfer on death deed, is a general warranty deed of the property. The seller guarantees that they own the property, they have the authority to sell the property, and they promise that the title is free from defects arising at any point in the prior history of the property. I always tell people, look at the name warranty. What's a warranty? A warranty is a guarantee The seller or grantor is guaranteeing they're the rightful owner, they have good title, and they're transferring good title. If you later have a title problem, the grantee has the right to go back to the grantor and say, fix the title for me. You guaranteed me good title. And I always say, how valuable is a warranty? It's only as good as the person making it. If you get an automobile repair done at a local shop and they give you a warranty on it, if you move away, how do you enforce the warranty? You got to go back to the original shop. You may not live there, they might be out of business. So a warranty is only as good as the person giving the warranty. Traditional uses, common uses for the general warranty deed were traditional real estate sales, arm's length transactions. Our agent tip is because the general warranty deed requires the grantor defend against any title defect regardless of validity. We've sort of pulled back. We've discontinued using the general warranty deed as our primary means of transferring the property. Instead, we typically use a limited warranty deed. There's still a warranty and a guarantee by the grantor, but that warranty is a bit more, it's not quite as broad and encompassing, it's a bit more limited. And we'll move on to that one next. In a limited warranty deed, it's essentially the same as a general warranty deed. The seller guarantees they own the property, they have the authority to sell, and the title is free of defects arising at any point in the past against the property. But they only warrant for defects arising what we call by and through the grantor. In other words, legitimate title defects. Well, what's the difference between a legitimate title defect and a not legitimate title defect? The answer is there are a lot of people who claim to have an interest in real property, and they will file a document that says, I'm claiming an interest in this property, when they really have no legal right to do so. They're not claiming it validly by saying, I was a former owner of this property and the deed was a forgery or fraud or not properly executed. They're not claiming a legitimate interest, but they're claiming an interest. In the limited warranty deed, the grantor only has to defend against valid claims by and through the grantor. The limited warranty deed is now the standard deed required in most residential transactions, including the GAR, the Georgia Association of Realtors Purchase and Sale Agreement. It specifies a limited warranty deed. So sometimes people ask me, should I be concerned about the type of deed as a buyer of the property? And what I tell them, the agent tip, is while the grantor's warranty is intentionally limited, an owner's best protection against title defects is owner's title insurance. We talked about the example that how good's a warranty? It's only as good as the person making it. If you have a covered title defect, do you want to find your former owner of the property, sue them in court, and ask them to fix your title problem? If you have owner's title insurance, you pick up the phone, you call a Fortune 100 company with $1 billion in claims resources and people specifically trained to deal with title issues, and you say, I have owner's title insurance and I have a title problem. Please make it go away. And that's why I say, in most cases, don't focus on what type of deed you are to receive. Focus on, well, I have good and marketable title. The Georgia Association of Realtors contract defines that as title that a title insurance company will insure at regular rates with no special exceptions. So really, although it's important to have a warranty of title, as an owner, your best protection is having owner's title insurance. A special warranty deed is a further limits, there are still warranties, but it further limits the warranty. The seller promises that they own the property, they have the authority to sell the property, and during their period of ownership, they haven't done anything to the that would cloud the title. Special warranty deeds are most commonly used by entities that typically haven't owned the property long and have limited information about its history and background. For example, banks and what we call REO, real estate owned by banks, REO properties, typically convey title by a special warranty deed. Relocation companies where the relo company takes title from the owner in order to immediately resell it to a buyer. Those are examples where special warranty deeds are typical and customary. And our tip is while the grantor's warranty is still intentionally limited, owner's title insurance is still the buyer's best protection against unknown title defects rather than trying to simply rely on the warranty of title in the deed. A quitclaim deed, and notice that it's quit with a T, not quick with a Quick. You hear a lot of people refer to them as a deed that's going to be claimed quickly, a quitclaim deed. It's actually a quit claim deed, and think of it as quitting your claim on the title to the property. Essentially, it says, whatever I own, if I own anything, and I'm not saying I have good title or any interest in the property, but whatever I have, I transfer that interest to you. There are no promises, there are no title warranties. And you might be thinking, that sounds terrible. Why would anybody ever want a quitclaim deed? Remember, the key difference is we're not guaranteeing our ownership and warranting our ownership, but we are saying whatever interest I have, I give to you. And there are cases where using a quitclaim deed is typical and appropriate. One is in divorce settlements. Um, Divorces create what we call a hidden interest in the property. A spouse may not be on title to the property, they may not be an owner, but equity in divorce might stipulate that they obtain ownership or that they get a payout from the sale of the property. So even though they're not on title, a lot of times a non-title owning spouse will be asked to sign a quitclaim deed to release their interest in the property. It wouldn't be appropriate for them to sign a warranty deed because they don't own the property. They can't provide a warranty or guarantee of title. So divorce settlements. Another case where they come up is where we clear title issues. Um, there are cases where the deeds haven't been done right in the past, and there is a question, who is the proper owner of the property? Um, a and because we don't know who has the best title, nobody wants to warranty the title. Um, but if we can get all the proper people to sign a quitclaim deed, we get them to release their interest in the property, and that way we know we've cleared up the title. For example, if we had a deed that wasn't properly executed from A to B, we don't know who has the best title. Um, but we know that the owner has, it can only be A or B. And I don't necessarily want either of them to sign a warranty deed, but if I can get both of them to sign a quitclaim deed, I know I've fixed the title. The only two people who had interest in the property are conveying it. So that's what I mean, where quitclaim deeds can often be used to clear title issues. Another place it comes up is in family transfers. After someone has died, typically they have to go to probate. probate the will if the deceased owner of the property had a will, or administer their intestate estate if they didn't have a will. But in a lot of cases, heirs, children, and spouses can obtain an interest in the property, and maybe they don't want it. For example, if a husband dies without a will, his wife and children share equally. And the children might say, we don't want the interest in the property. We want our mother to have it. It wouldn't be appropriate for them to warrant their ownership in good title, but if they will release their interest by a quitclaim deed, we'll look at it and say, yes, the husband's interest went to his spouse and his children, and all of his children quitclaimed their interest back to the mother, so she's now the rightful owner of the property. Removing an ex-spouse from title, again, under the heading of divorces. They might not be in a position to warrant their title, but they will release their interest in the title. The risks with a quitclaim is there's no warranty or guarantee of title. The grantor is not guaranteeing ownership. Because of that, a lot of consumers misunderstand what a quitclaim deed is or why we would use a quitclaim deed. There's also a perception that somehow a quitclaim deed, for example, I want to add my new wife to title because the property's titled only in my name. And they say, let's do it by quitclaim deed. And I say we could, but let's do it by warranty deed instead. And they say, why do you recommend that? And I say, here's why. When you have a quitclaim deed, typically, when we have a series of warranty deeds, we call that a chain of warranties. A warrant that he got good title from B. B warranted he got good title from C. And we have this chain of warranties. And when you do a quitclaim deed and there's no warranty, you've broken the chain of warranties. So I say, instead of doing a quitclaim deed to add your new spouse to title, let's do a warranty deed. There's really no risk to you because it was already warranted to you, and you are now in turn warranting it to you and your new spouse. So there isn't truly a risk or a danger in you agreeing to this warranty because it was already warranted to you. And what it also does is in the future, if you were to have a title problem, the person you've added to title is not a covered person under the title insurance, and it might limit your ability to make a title insurance claim. But if you add them by warranty, now you're on the hook for the warranty, and your title insurance covers your warranty of title. So there are reasons where we would say, let's do it by warranty deed instead of quitclaim deed. On the flip side, the information I presented on the slide, we say these are times where it would be appropriate to use a quitclaim deed instead of a warranty deed. Several other different types of deeds that we use and you're likely to see. An executor's deed and an administrator's deed are essentially very similar. When you die either testate with a will or intestate without a will. If you die testate, your heirs will probate your will. And let me back up one step. When you die, all your property by operation of law automatically goes into your estate. And the only person who can handle your property is a person appointed by the probate court as a personal representative. If you die testate, we call that personal representative an executor. If you die without a will, the process of administering the estate is similar to probate, but it's called an administration. And the personal representative is called an administrator. So an executor's deed tells me that they died with a will and an executor was appointed. An administrator's deed tells me they died without a will and an administrator was appointed. Executors and administrators' deeds are used by the personal representative if the estate wants to sell the property. So when we use an executor's or administrator's deeds, our considerations first are we want to verify that all the proper probate steps were followed, that the probate court issued a final order, they issued letters testamentary for an executor. That's letters testamentary, or the probate court authorization that this person is now empowered as the executor. We also want to review any probate court requirements. What was the executor required to do? And lastly, we want to make sure that the executor has the power of sale. Does the executor have the power to sell the property? Typically, that's given to the executor in the will, and it carries through in the probate process. If the will did not give the executor the power of sale, or if an heir challenged the validity of the will, the probate court might still appoint them as the executor, but limit their power. You are the executor, but you do not have the power to sell the property. If you want to sell it, you need to come back to the probate court and get approval for the sale. Fortunately, that's the exception rather than the rule. In most cases, the executor has the power to sell the property. It's the rare exceptions where they don't. Same thing with the administrator's deed. If all the heirs sign the petition to administer the intestate estate, the probate court issues letters of administration appointing the administrator, and the administrator generally will have the power to sell real property. If for some reason the letters of administration do not grant the power, the administrator has to go back to the probate court, what we call a petition for leave to sell, to get permission to sell the property. Last is a trustee's deed. When property is held by a trust isn't a legal entity in its own right. Property held by a trust is actually held by a trustee for the benefit of the trust. So our key questions when property is being transferred out of a trust is there a valid trust document outlining who is the trustee and what are their powers? Is the trust active? Does the trustee have the authority to transfer the real estate? And a lot of times we'll require a trust certification. A trust certification is simply a certification by the trustee that recites those key three things. There is a valid trust. It's still in effect. I am the trustee of the trust. And in the trust, I have the power to sell real property. So those are the key things we look for when we have a trustee's deed. One thing you as an agent can do to help ensure a smooth closing when a trust is involved is know that the closing attorney is going to want to see the trust documents. We need to review them, confirm the trustee, confirm their power to sell real property. So when you see that a trust is involved, and my joke is, you can blame it on the closing attorney. You can tell them, I want to make sure you have your trust documents prepared, that the closing attorney will need to see them. Sometimes trust can be lengthy or have significant personal information. Maybe it's a special needs trust. And the trustee says, I don't want to share the trust with you. And in those cases, usually whoever drafted the trust prepares a short version of the trust. We call it an abstract of trust or a certification of trust. And I call it the Cliff Notes version. So when I ask the trustee, can I see your trust? And he says, no, it's lengthy and it has personal sensitive information. I say, did the person who prepared the trust give you an abstract or certification of trust? And they say, yes, I've got that. And I said, well, let me see that. It takes out all the personal information. I call it the Cliff Notes or short version. And really, That's what I'd rather see. I really don't want to read a 300-page trust. I just want just the facts, ma'am, the short version that confirms everything I need to know about the trust. Last are conservators, or guardians' deeds. If a person is incapacitated, one of their heirs might go to court and ask the court appoint them as a fiduciary to manage their affairs. You might remember that Britney Spears' father got a conservatorship and guardianship for Britney Spears for a period of time. The difference between the two is one is, I believe the guardianship is for the person, the conservatorship is for the property. And those are good legal instruments, and they are valid for transfer of real estate, depending on how the conservatorship or guardianship is written. And depending on the authority granted, we might need additional court approval, a petition for leave to sell. And I mentioned how that might come up in the probate situation. The person might be appointed as a personal representative, but not have the power to sell. Same thing here. They might be appointed as conservator or guardian, but they don't have the power to sell real property. So we have to go back to the probate court that issued the conservatorship or guardianship and get permission, court approval for the sale. Because of that, when we have a conservator or guardianship, it's a variable. It could take longer. It really depends on the probate court, how backed up is their docket, and how quickly can they give us the approval we need for the sale. Sometimes we need additional support documentation. The probate court handling the guardianship or conservatorship might say, before I approve the sale, I want to see an appraisal or a BPO or a CMA. I want to know that you're selling at a fair price. So sometimes additional support documentation is needed when there's a conservatorship or guardianship. Deeds pursued. When we have a divorce, we need to make sure that all the terms of the divorce are complied with, and that if the divorce specified any quitclaim deeds from any of the spouses, we get the quitclaim deeds or special warranty deeds, whatever specified in the deed. Our agent red flags when we have a divorce, and we have to look at not just current divorces, but old divorces. Our seller now was divorced 5 years ago. Does she have the authority to sell the property? I won't know until I look at the divorce and see what it required and make sure all the steps were required. Did it require a transfer from the ex-spouse? Was the transfer completed? Was the transfer deed recorded? Are there any payments or payouts specified in the divorce settlement? And have they all been met? We had an old divorce, and the wife owned the property for many years post-divorce. And when she wanted to sell it, I said, well, let's look at the divorce decree. And what the divorce decree said was the wife gets sole use of the property until the youngest child reaches age 18. Once the youngest child reaches age 18, the wife must sell the property and split the proceeds with her ex-husband. Had we not looked at the divorce decree, we wouldn't know of that requirement. So even for old divorces, we have to look at the requirements and make sure that they're met. Also, when you have a divorce and it specifies a transfer from one spouse to another, go ahead and get that done at that time. One common problem we see is a failure to complete post-divorce transfers, and that creates title problems later. I had a divorce that required the ex-husband to sign a quitclaim deed to his wife, and it was 10 years ago, and the deed was never done. And I was really concerned. Are we going to be able to get the ex-husband to sign the deed? Is he still alive? And I asked the ex-wife, and she said, oh, we're still on good terms. I can speak to him. He'll be happy to come in and sign a quit claim deed. So it worked out to be not difficult. We avoided what might have been a problem because we were able to get the deed signature that we needed. uh, Deeds executed by entities like LLCs, corporations, and partnerships. When an entity owns the property, they can still sign each of the different types of deeds that we've seen: the general warranty deed, limited warranty deed, or a quitclaim deed. But the key things we need to verify when an entity is signing a deed is the entity status. Entities are created under state law, and we want to make sure that the LLC is validly formed and still in existence. We want to know who's the authorized signer, who is authorized to sign for this LLC. And the way we do that is to look at their corporate documents. If it's an LLC, the corporate document is called an operating agreement. If it's a corporation, it's bylaws. If it's a partnership, it's a partnership agreement. But it should specify who is the corporate officer who can sign on behalf of the entity. Sometimes the corporate documents are not clear on that. And in that case, we ask for a corporate resolution. And that's where all the corporate officers sign an agreement that says, we've agreed to sell this property, and we've agreed that John, as the president, can sign the deed on behalf of the corporation. One thing that you run into often is you might be dealing with property where the seller or buyer is an entity. How do you know who can sign for that entity? Never assume the person you're dealing with has legal authority to sign for that entity. You can ask them, can you show me the portion of your corporate documents that says you are authorized to sign for the entity? And again, um, you can blame it on the closing attorney. You can say this will be necessary by the closing attorney. So let's go ahead and do it now. Some common red flags agents should spot: deeds impact the ability to transfer title. Look for unrecorded deeds. People tell you, I'm the owner, but you don't see a deed in the deed records to their name. Or they say, I'm the owner, here's the deed, and they have what appears to be a deed executed by a former owner of the property. Unrecorded deeds are a red flag. Family transfers without legal advice. We call them kitchen table deeds. We had a homemade deed drawn up from one family member to another. It deserves some additional scrutiny to make sure that everything is legitimate. Recently deceased owners. We talked about how when an owner is deceased, property automatically, by operation of law, goes into their estate, and the only person who can handle it is the personal representative, the executor or administrator. Situations where probate is pending. The deceased died, we haven't completed probate. We're going to need to finish the probate and get a personal representative appointed so that we have someone who can sign the deed. Missing spouses. Sometimes I look at title and it was formerly owned by a husband and wife, and the later deed was only signed by the wife. And I ask the question, what happened to the husband? He had an interest in the property, and I don't see that he ever signed a deed. And it could be they held title as joint tenants with right of survivorship. He died, and when he died, his interests passed to his spouse. And I say, that's great. Let's just record an affidavit in the deed records to clear that up so nobody will ever have this question again. Issues about trust ownership. When we do a closing involving a deed out of a trust, we typically record a short 2-page trust affidavit signed by the trustee that recites that the trust was validly formed, is in existence, they are the trustee, they have the power to sell, so there's record of it in the deed records. LLC ownership confusion. I say LLC, but we can change that to entity. We deeded it out of ABC LLC, but we don't find ABC LLC exists. It could be it was formed in another state. Maybe ABC LLC is a Florida LLC, not a Georgia LLC. Sometimes the deed is prepared incorrectly. It recites ABC LLC, but it was actually ABC Incorporated. So that's another deed issue we look for. And that also falls into the heading of name discrepancies. One place we see name discrepancies a lot is where the grantor might be a senior or junior or third, or some deeds have middle name or middle initial and others don't. And we want to confirm, are we dealing with the right people? It originally was deeded to Bob Brown Sr., but the later deed was out of Bob Brown or Robert Brown. Are we talking about the same person? And we need to find a way to verify name discrepancies. Before I go on to my um, next slide, I want to take a few questions from our chat window. One of them is, will a will limit selling a property? And the answer is, if a person died and have a will, one thing that I have to explain to people a lot of times is a will has no legal significance or meaning. I have people that run around and they say, I'm the executor because it says so in the will. And I tell them, that's great. You need to go to probate court, get the will approved, and get appointed as the executor. The will by itself does not confer any power until it goes through probate and it's recognized by the probate court. So the answer is, will having a will limit selling it? Ideally, it will make it easier. You go to probate court, probate the will, get letters testamentary, and have the executor appointed who can sell the property. If for some reason the executor does not have the power, they might still be appointed, but they have to do a petition for leave to sell. Next question dealt with property taxes to new warranty. A warranty taxes constitute liens against the property. At every closing, the closing attorney should ensure that all property taxes are paid current through the date of closing, and the buyer becomes responsible for property taxes that come due after the date of closing. But what if something happens, if the taxes were missed, or what we've seen, the taxes are changed retroactively? It was vested in grandmother's name and she died 2 years ago, and the heirs continued to pay the taxes. And later, after we've sold it, the tax department says, wait a minute, she was getting a senior exemption and a homestead exemption, and she died 2 years ago. She got those exemptions improperly. They will retroactively change the taxes, potentially leaving the new owner with a problem. And what they'd need to do is approach the seller under the warranty of title. These are taxes from your period of ownership, and you're responsible for paying these. Next one dealt with a situation to quiet title due to the heirs stating that their deceased father owned the property, however, was never on title or satisfied a divorce or paid off a mortgage before death. It's kind of a broad question, but I'll give you a short answer. A quiet title action is something that can be brought in the clerk of superior court of the county where the property is located, where someone wants to prove to the probate, or excuse me, to the superior court, I am the rightful owner, and either acknowledge any, and I also acknowledge that it's subject to a mortgage, an outstanding mortgage, or that mortgage has been paid off. It's not subject to a mortgage. So a quiet title action is an action to confirm ownership and any potential owners in the property are notified that there's a suit for quiet title, and they're allowed to bring up any objections to the quiet title. So a quiet title can be used whenever there's some question about ownership or liens. There was a question, if I add a name to title, will there be personal tax consequences for the new person? I will tell you that each situation is different. Consult your tax advisor. In most cases, if you add a spouse to title, there's an unlimited spousal exemption. Spouses can transfer property between them without taxable interest. If it's not a spouse, there are potential gift tax considerations that might be treated as an advance out of the estate. Um, the other thing to know is when you add someone to title, they're an owner of the property. If they get a lien filed against them, it attaches to the property because they're an owner and their liens attached to the property. Does an affidavit to or on the deed filing notify lien holders? Ninfa, can you give me a little more background for the question?
Hey, Doug. Um, yeah, I was just curious if you file affidavit to what I needed to do, if it
Sure.
if
Let
they
me
all the lien holders are notified.
An affidavit is just a recitation in the
Information.
public deed records. In most cases, it is noticed to the world because the affidavit is filed. It doesn't necessarily on its own require notification to anybody other than recording the deed. The example I'll use is husband and wife are joint tenants. One spouse passes away. We record an affidavit that tells the world in the public deed records husband and wife were the owners as joint tenants with right of survivorship. One spouse passed away, and we prove it by attaching a copy of the death certificate. By virtue of the joint tenants, the surviving spouse became the sole owner of the property. And we don't have to quote unquote notify anybody, but we do file it in the public deed records. And in that sense, it's notification to everybody, it's notification to the world. Our next question dealt with who files the TOD, the owner or the attorney. If you want to do a transfer on death deed, I would encourage you to work with an attorney. Our firm can assist with those type of deeds where you just indicate who do you want the property to go to when you die, and we would help you execute the deed. I've used that term a few times, and it's an important concept in a deed, and I want to make sure you know what executing a deed means. It means the grantor signs the deed in the presence of a witness and a notary public who also sign, and the notary affixes their seal. A deed isn't eligible to be recorded in the deed records unless it has those three signatures and the notary seal. Signature of the grantor, signature of the witness, signature of the notary, and the notary seal. So that's what execution is. So if you want to use a TOD, work with an attorney who can prepare the deed as you direct. They can help you in getting the deed executed, signed, witnessed, notarized, and the attorney can record the deed in the county deed records. The next question was, can a trust and a TOD work together or must uh, have one or the other on file? My answer is there are really different ways to account for what you want to do in probate. If you have a trust, typically you don't need a transfer on death deed. You'll transfer title to the trustee of the trust, and that is how the title is transferred. That's different than putting it in a TOD where the ownership remains with the owner, but they've specified who gets the ownership when they pass away. And that was one of the things I alluded to when we spoke about a drawback of the Todd is that it can interfere with other estate plans that you have in process. In the example I use, a Todd's probably not appropriate if you want to put it in a trust with a trustee. So there are really different ways of estate planning. The one deed I didn't put in the slides, but I want you to know the term is a security deed. A security deed is where a borrower grants a security interest in the property to the lender. And that's really common. Every time a borrower borrows money against the property, their lender wants a security deed, which creates a lien against the property. And it gives the lenders like security deeds for three reasons. It says the lender has a loan against the property, the lender has the right to foreclose if the buyer doesn't pay, and if the buyer later sells the property, the loan has to be paid off before anyone else can get clear title. So that's the purpose of a security deed. It's a way for a borrower to grant a security interest in the property to the lender. There's a question, how would I get a joint tenants with right of survivorship? Um, it's not uncommon that a husband and wife hold title. If the deed doesn't state that it's joint tenants with right of survivorship, it isn't. It's tenants in common. And a husband and wife look at the deed and they say, but we want to be joint tenants with right of survivorship. I say that's no problem. The husband and wife can deed the property from themselves to themselves as joint tenants with right of survivorship. And in that new deed, they're creating the joint tenants with right of survivorship. So that can be easily done as long as both parties are still alive. The question, do I need to refinance to create a joint tenancy? The answer is no. It can simply be done by a joint tenants deed. The last question, is a living trust better than joint tenants with right of survivorship? Um, a trust is far more all-encompassing because a trust can accomplish a lot more things just than other than transferring title to real estate. If a husband and wife own property together, in most cases, they want to hold it as joint tenants with right of survivorship. If one spouse dies, the other gets the property and vice versa. There are situations where spouses say, that's not what we want. We have testamentary trusts in our will. It says my half interest goes into a trust. And in that trust, my spouse can use the property for the rest of their life. But when they die, my half interest goes to my children from my former marriage, and hers works the same way. When she dies, her half interest goes into a trust, and her half interest goes to her children from a prior marriage. So it was actually a pretty clever way of saying, I don't want to leave my half of the property to you. I'll leave it in a trust, and you can have it as long as you live. But when you die, the proceeds are split evenly between the two trusts, so their respective children, respective heirs, get their share of the property. So the question is, a living trust better than joint tenants? I'd say it's more all-encompassing. If you simply want to leave property to a co-owner, a joint tenancy is fine. If there's more to it, you might want to consider using a trust. The agent's role, I don't expect you to be able to draft legal documents, interpret estate plans, or provide legal advice, but you should know enough to identify concerns, be able to ask questions, encourage them to get legal help with whatever it is they want to do with their deed, and communicate early with the closing attorney. If I know what the parties want to do, in most cases, I can help them do that. If a person buying the property is a single individual and they say, after I buy the property, I want to do a transfer on death deed so that I can leave it to my children when I die. I say we can handle that for you, separate from the closing. We can create the Todd, but let us know and we can do a lot of these things. Are there any other questions about deeds and the material that we've covered today? Think of the closing attorney as your partner. A good closing attorney should be somebody who can be involved with you early in the closing, help prevent delays, resolve title concerns, coordinate probate matters, verify authority to sell the property, and keep transactions moving. So communicate early and often with your closing attorney, especially if there are any concerns about title or the transfer of title. You'll find my contact information here. So please feel free to reach out if you have questions or need help. You'll know how to reach me. We're going to take our Zoom session. We record our Zoom sessions. We clean them up, add our title credits and theme music. We post them on our YouTube channel and then link to them on our website. If you check on our website in about another 7 to 10 days in the resource tabs, you'll find this presentation. You'll be able to go back and re-review it for anything you have a question about, and you can share the link to any other agent who would benefit from the materials that we covered today. One agent said, "This is great. I would like a copy for my clients." And the answer is just feel free to link to the video. And we'll have the video on our website here in 7 to 10 days. There was a question, are you sending slides to participants? We don't customarily do it because we don't always collect email addresses. We use a standard Zoom link. But if you do reach out, we're happy to. We have the PowerPoint saved as a PDF. If you'll reach out using the email address on the screen, I'm happy to send you a copy of our PowerPoint today. I will add one slide in that before I send it out, and that's general things that attorneys always say. I hope you found our information today helpful and educational. Remember, it's general information. It isn't legal advice for any particular situation, but it is good, helpful, educational advice. And you can also email Tracy Wood, twood at shafritz-dean.com. She'll be happy to send you the presentation. And we'll just add the little boilerplate slide that it's not legal advice, so on and so forth. And with that, I'd like to thank you for joining our Business Builder Speaker Series today. One of my favorite quotes is from Kenny Rogers in his song The Gambler, and that is, I hope you found an ace that you can keep. So I hope you took some good information and value from our time together. I appreciate you being here. If Shafritz and Dean can help you with any of your closings, please stay in touch, and we'd love to assist you where we can. Thanks for your time today, and we will catch you again soon. We look forward to seeing you next month on August 19th at 10 a.m. With Skip Wilcox from Kairos.